everyone to come in. I think, just give it a couple of seconds. My name is Teresa Woods Peña. I'm here from Woods Law Group, the principal attorney, and just wanted to welcome everyone to today's presentation through the CUBE Foundation. So thanks everyone for coming. You should see on your screen the actual document, the presentation that I'm going to be walking us through. So can someone give me a thumbs up or a comment in the chat if you're seeing that? Okay, good. Thank you. Thank you. Great. So I'm going to get started walking through the presentation, and then there'll be time for questions and answers after we get through all of the material. It's been an incredibly stressful time, as I am guessing you all are aware, when it comes to immigration. As with so many things in 2020, there are a lot of changes. Everything's kind of minute to minute, and immigration is certainly no exception. So we're going to sort of tackle that at the end. I do want to give you sort of a spoiler in the beginning, and you're probably aware if you're following the news, there's a bit of good news as far as student visas are concerned. So the administration's directive not allowing student visas for students who are going to be attending institutions that are exclusively online due to COVID, that's been canceled. That restriction is not happening. So that's a little bright spot. I don't think I'm giving anything away by telling you that in the beginning of the presentation, but I thought we'd start off with a little positive news. The other things we'll cover at the end of this talk are travel restrictions and consular post closings and what that's looking like. There's also a little bit of breaking news on that front. So we'll kind of cover that at the end, and there may be some questions around those particular bits of information. So without further ado, I want to welcome you. If you are, on an O visa, there's a lot of things I'm going to say that you may already know, but I think it's always good to know in more detail kind of what you've gone through and what maybe another way to do it going forward, depending on how you process. We're going to cover what the artist visa is, so who can apply, right? Who does it cover? Who does it apply to? What do you have to show? Like, what evidence do you need to actually present a case to immigration or U.S. Citizenship and Immigration Services or USCIS? What is the process? What is the timing? I'll also talk a little bit about fees, but fees change. So I want to just give you the caveat that immigration is famous for changing the fees for each form. So always, always, always check it. Attorney's fees vary, but we'll go over what those are. And then your preparation, what do you need to kind of put all of that together? At the end, as I mentioned, we're going to talk travel restrictions, kind of a moving target a little bit, right? There's always news and changes, but we'll cover what we can. U.S. consulates, bit of breaking news about that. They're planning to reopen them. And then student visas, as we've talked about, the little bit of bright good news. All right. So in terms of who can apply for the O1B visa, we're looking at people in the arts, right? Visual artists, motion picture and television. So there is another O visa. There's the O1A for scholars, members of the business community, for people in sports, right? There's the O1A, and then there's the O1B. So most of you are probably in the arts and qualify or are hoping to qualify for the O1B visa. It covers visual artists, designers. This is not an exhaustive list, but if you're a curator, critic, right? Those are professions that are all in the creative fields: stylists, makeup artists, fashion designers, musicians, architects, dancers, and then film and television, as we talked about. So that includes film producers, directors, actors, all of the above. All right, so what do you need to show? What do you have to show? What is the evidence? The way the regulation is structured, the law sets it out as like, you either need a major award on the level of an Academy Award, a Grammy, an Emmy. These are just sort of the most common ones that I think people can associate. In the arts, of course, the awards are different. But, you know, if you've got the equivalent of a high-level award in your field, that may be enough. That may be all you need. Or 3 of the rest of the categories. So you don't need to show everything that we're going to talk about, but you do need 3 of them. I can tell you what the most common ones are as we go through, like what the most typical application looks like. I'll kind of do that after we go walk through all of them, but you know, there is sort of like a way that the visual arts application, the shape that it takes, with maybe like an option to add a 4th category. Usually there are 3. It's case specific, so it really depends on what you've done, what your CV looks like, what materials you have to present. So this is very text heavy, I apologize, but I wanted to list out the actual terms, the language that you find in the regulation, to give you a sense of what this immigration officer is looking for, because I think there can be a real disconnect between, you know, sort of speaking different languages, right? Like artists sort of talk about their work in a certain way, and immigration officers are bureaucrats and are looking at things through the lens of qualifying, right, for like a legal category. So it's sort of like they have sort of this square peg hole that they're trying to fit you into, and you know, you're sort of smoother and rounder and more creative, right? So it's like finding the right fit between what you've done and what the requirements are. So in that sense, I think the language is particularly helpful to look at, and we'll break out what it means, you know, each category. So in terms of awards, we talked about what that is, if it's going to be just a standalone category. I don't think I'm, you know, telling you too much, but, you know, to say that none of my clients have that, right? Nobody really has just one award that gets them the visa. That would be really way too easy. I'm sure it happens, you know, somewhere in the world that does happen, but that's not usual. So awards, you may have awards, and you may have that you've won, and you may have nominations for things, or you know, awards that you didn't win, but that you got some level of recognition for, or awards that, you know, even to be considered is prestigious. So that goes into a different category of evidence. Particularly, that would go into significant recognition. But we'll get there. So the first category you're looking to present, and in terms of like what the standard visual artist application looks like, this is one of the categories to think about, that probably applies to you, is leader starring participant. So what's important about that category is that it has a lot of moving parts. It sounds probably pretty simple. Were you a leader starring participant in an event or production? That sounds very simple, but there's a couple of components that make it more complex. And I think therefore more exciting, and maybe an opportunity to be creative. So it's both backward looking and forward looking. So what you need to present is information about the work that you have done in the past, but also what you plan to do in the future. So what is your plan for future work? And then for both the past and the future, how prestigious or distinguished were those events or productions? To just dive right into it, right? When we're talking about the events from the past, this is where, you know, your portfolio, your CV is going to be really crucial. Having documentation, if you have done exhibitions, if you have presented your work, you know, in public places, was it covered by the press? That would be presented, right? Like, so, you know, using your invitation cards for exhibitions, to take just, you know, a very standard example, to show that the exhibition is a real thing, was a real thing and happened, but then press coverage for that event is what's going to drive the point home that it was prestigious and distinguished. And then where did the event take place, right? Like what was the venue? Because press about that venue we also use to show that the event was distinguished. In terms of your role being leader starring, so really immigration breaks these things apart, and they may approve part of the category, but give you a request for evidence on another part of the category. So it's important that all 4 of these components for leader starring participant are covered. So was your role leader starring? And yes, group shows are also important and recognized and very, very valuable to your application. The reason I say solo is because of this leader starring. So it's very easy to argue that your role was leader starring if it was your exhibition. If you were in a group show, that doesn't mean you can't demonstrate that you had a leader starring role. It just means you're gonna have to maybe be a little more clear and a little more demonstrative about why your work was important to that exhibition. And then if you have a mix of group and solo, how you kind of layer that and how you present it, you can be very strategic about that. If you only have group shows, that doesn't mean you can't get this category. It doesn't mean you can't show that you had a leader starring role. So I just want to be super clear about that. I've had several cases approved where there was no solo show and the category was approved without a question, without a problem. In terms of the future, this is an area that you really, it changes. So far I've seen USCIS kind of pivot a little, and in terms of what they're looking for, switch it up. Currently, right now, what they are looking for can be proven. It used to be that you could prove it through a letter from someone who could talk about your future role. Right now, the way that we do it most often is by showing your offers of employment, and we kind of work in language to those contracts, those offers, talking about your role being leader starring and talking about how the events and productions are distinguished. So it's really crucial to kind of think about the kinds of offers you're getting, and we'll talk about it again when we talk about itineraries and offers of employment. But when you're thinking about your plan for the next 3-year period, if you're applying for an visa soon, you want to think about where you're going to do your work, who you're going to partner with, because in terms of this future distinguished productions, that can make or break the application. It doesn't mean you can't do, I've had several clients, and I have several clients now who have sort of work that pays the bills that's still in the arts. That's okay, and that can be also included in your itinerary, but there needs to be enough things that are distinguished, that are, with, let's say, an art space or a gallery that has press that could be submitted to say, yeah, this space has a distinguished reputation. There was an article. It doesn't have to be about you. The press in that instance would have to be about the venue. Okay, and right, so if your role is in a group, so if you're, on a production team, or if you're, let's say, a violinist in an orchestra, right? Like if you're part of a group that's doing creative work together, and I think that's very, very common and something that, everyone should sort of think about, that is a challenge that's built into your work. I think some professions more than others, right? Musicians in an orchestra is classic. Graphic design teams, film teams, animators, right? There's a lot of creative professions where it's sort of built in this challenge of showing that your role is leader starring. So what I would say is, depending on where you are in this process, if you're looking forward to applying for an O1, thinking about being really strategic in getting your press, getting your name mentioned, getting your work photographed, getting your a quote from you as, you know, so, right, like putting yourself out there in a way that, you know, you kind of can later have that to support your application. So I think really recognizing and getting comfortable with the fact that as an international artist, there are going to be certain things that are expected of you that, you know, you may not have to deal with otherwise, right? Like just, it's unique to your situation. And you may be fine with it and you may be very comfortable with it, and that's great. But just knowing that you have to do it because it sort of helps, it's going to drive your application. And not just your first O1, right? But like if you're going to be on multiple O1s, and plenty of people are, there's no limit to how many you can get. You have to kind of keep that, keep those wheels turning. So that's leader starring. It's a little bit more nuanced than it appears, but it is certainly, I think, a standard category for a visual artist. And as long as you know, dot all your I's and cross all your T's, it's fine. I mean, you just have to know what they're looking for, and then know the best way to present it. Okay, press. So as you can see already from leader starring participant, press is built in, right? Where's the press about the venue to show it's distinguished? Where's the press about your work, your exhibitions, who's written about them? That matters already before we even get to the press category. So press is crucial to the whole application. That's why I say, like, get really comfortable figuring out how to navigate the press. You know, how do you get before the media? How do you get your name quoted? How do you get your work photographed? Because that is like essential. Press is a category unto itself. So the press must be major media or a trade publication. So things like Hyperallergic, Freeze Magazine, Art Forum, right? There are several that are just like, they're big. There are ones that are smaller that are equally good if they're trade publications. So thinking about important blogs, important social media more and more is being recognized. I just caution that that can't be used on its own, right? It can't be all blogs and social media for your press category. There can be a smattering throughout, you can pepper it through, but you really need to have some articles in the press. So question and answer style interviews with you, like a sit down with the artist is the preferred, that's what they like to see. USCIS like sort of this classic, let's talk about your artwork, right? So it needs to be about your work. It can't be about you and like your hobbies, but you as an artist, you and your work. And then that can be, you know, that can be a video, right? That can be on the news, that can be in any format. But you really do want to get some press in major media. Major media is determined by circulation numbers. So it doesn't mean that you need to get an article in the New York Times or the Washington Post or like a big giant paper in your home country. It means it needs to be major media. So what are the circulation numbers? So I think really, and I know that it's hard, this is not like easy, you know, even for artists who have, you know, great careers, it's really, press is not something that comes easily. But there are things that you can do to make it easier. So thinking about, you know, what press is present here in the US from your country, right? Who's here? What community can you tap into? There are a lot of news outlets, right? So getting an article maybe in ethnic media is easier, depending, right? Depending what it is. But the circulation numbers might be significant, and that might be meaningful, and that might be fine to satisfy USCIS's requirement that it's major media. So that's what they're looking at, and that's what, when we actually physically make the file, we submit the circulation figure with the article. If there's a translation, certificate of translation, circulation number, and information about the publication, right? So all those things. I would say writing articles and publishing them doesn't cut it, but having sort of, you know, press releases about your exhibitions that are pre-cooked and drafted already make it really easy for whoever you're pitching it to to just pick it up and publish the article without, you know, too many changes. Drafting, having things drafted, you know, and just pitching the story, right? Artist from, you know, X country, living in New York City, living in the United States, right? Like there could be just, you know, you can just do a simple hook and a lead and pitch it to them. So I say that for people who are struggling with press. And I also want to highlight that everyone is struggling with press, right? Like it's not an easy thing to get. Sometimes you can build it up over time and then just maintain it, and that's great, but it's not a given. So important to think about it and strategize ahead. Sorry, there are some questions and I want to make sure that I just covered everything that's being asked. So I think it is important to have an attorney to do an O1B application. You can do it yourself. It's just this sort of insider information. Like for example, on lead and starring participant, where there's been a shift in terms of what's acceptable to USCIS, you wouldn't know that because you don't live and breathe this stuff, right? Like some of us do. So like if it's not something you do regularly, you know, you're gonna wanna have a lawyer to do it. And I would say a lawyer that specializes in this area, it would be the preference. You know, there are tons of immigration lawyers, but if they're not specialized in O visas and working with people of extraordinary ability, those kinds of challenges, there are things that they may miss. So it's sort of a particular niche area. And right, things are crazy right now, so it's better off to work with a lawyer. There are also some really great people working in this area, so it's, you know, it's not as if you know, you're probably going to be in good hands if you do your homework and your research about who you're working with. Okay. Okay. The next category I want to talk about is critical role. This is one that I would say is not in everyone's application. This isn't going to be everyone who applies. This is going to be fact specific. It's going to be dependent on whether or not, you know, there's some questions that I would ask that would get to the heart of this in terms of your experience. But like, if you've had, for example, work sold by a gallery, and the gallery can document that and would be willing to sign a letter saying that your work was critical to the success of the gallery. Equally, if you've worked on some, you know, a graphic design project and it won awards, and the team lead would be willing to say your work was critical in winning that award. So there are a lot of, but you do see the like equation, right? Like your work was critical to the success, whatever that success is, winning an award, financial success, profit, right? All those things. Or if it's just like reputationally, you know, like information-wise, reputation was bettered because of your involvement, because of your name, because of your reputation and association, things were, things took a turn for the better, you know, for the art space or the gallery. So in this category, you want to show press coverage as well of the organization that you're talking about to make sure that it's, you know, documented, that it has a distinguished reputation. But it's really about getting letters and then press about the work. So if, you know, whatever the project was, taking the graphic designer example, right? So documenting the award, why it was a competitive award, that, you know, your work was covered in the media for having won that award, press about whatever the exhibition was in the case of, you know, a gallery. So it isn't something that applies to every application, and it isn't necessary to have this category to get an O1 visa. But it can be nice to have a cushion, to have an additional category if it fits, if it's something that, you know, is true, and you can kind of get the letter, get the press, get the information. Commercial success, really what they want to see here Again, we're dealing with, immigration, so they're thinking, very linearly and very in these boxes. Commercial success is really limited to box office receipts, and it's pretty much reserved for film and television. I'm not saying there aren't attorneys who use it more creatively and open it up for visual artists, but really what they want is, I just think opening it up means opening yourself up to some risk, knowing that the way it's viewed, the way it's presented in the regulation is really about box office receipts and film and television. So, and then even in that instance, it doesn't always, it's very uncommon that it applies because commercial success, has to be documented, and oftentimes that's not the case. Things are not always commercially lucrative, even though they are successful. Okay, so moving on to significance. This is what I like to call the letters category. Nobody else calls it that, like that's not like a thing, but in my head, it's like where your most robust letters, kind of drive the point home that you're extraordinary. So you're looking to get letters from the highest titled, the highest level people in your field, in your world, in your network, right? So who can you tap that that's very high level, that would be willing to sign a letter about your work, who's familiar with your work, who you've worked with, all these things. You don't necessarily have to have worked with them. Really what they're serving it as is an expert who can comment on your work to say that your work is important, extraordinary, meaningful in your field. So in the world of contemporary art, your work has meaning, relevance, importance, lasting impact, right? So there's a lot of language that we use that is, some might say, you might feel uncomfortable reading this type of letter about yourself because it feels a little bit lofty, and it feels like we're saying, you're the next big thing or the already big thing. But that's what you need to do and to document, and it's true, right? We don't say anything that isn't true, so it's just a matter of like finding the right words and the right language. And I know from working with artists that it can feel a little bit as any letter of recommendation can feel, right? You might feel a little on the spot that like someone's saying how great you are. So this is the category where you do that, right? This is sort of, I think, what the application for an O1B is famous for. This is the lofty letters category. So we also put in here awards, grants, fellowships, residencies, those kinds of things, award nominations. So if there's something particularly prestigious that, even getting nominated is a big deal, we would put that here. Right, residencies as well. The format of the letter is that, it's a little bit different than a normal letter. So we would talk a little blurb about you as an artist, then the signer's bio, why are they the expert to listen to? Who are they? So that's why we need to think about like, who's at the highest level. People who are at institutions is what you want to be thinking about. Arts institutions, curators, writers, critics, those types of people. So you're looking for like neutral expert. Academics, as long as they're not talking about your student work, as long as they're talking about you as a professional, are great because they're neutral. They're at an academic institution, right? They're not, gallery owners are where you can kind of run into a question mark, not necessarily that they wouldn't be helpful or useful for this category, but you want to think about the perception because they do have a profit motive. So thinking about institutional people who can really comment from a neutral institutional perspective. Okay. So the next categories are high salary. I don't think I'm giving anything away about anyone's case by telling you this is not frequent. This is not a common category for artists. That said, there are times when it does apply. There are times when artists have sold work consistently at a high level, they earn well, they're regularly selling their art, and it's documented that they have a high salary. the key is the documentation, right? As with anything legal, this is no exception. You want documentation. So, or, you know, if you're working, if you're an architect and you work in an architect firm or graphic designer and you're at a large graphic design firm, there are lots of ways that you are possibly getting a W-2 and you may have full-time employment. So if that's your situation and your salary is high, that can be the way that it's documented. Similarly, an accountant's letter. So an accountant can do a letter about your taxes and talk about what your salary was for the year. That's a way to document high salary. In addition to the documentation of your salary, we also need to supply, because it's relative to your field, so we need to supply like a baseline for what people typically make in your field. So information from Glassdoor, information from the Bureau of Labor Statistics, particularly the Occupational Employment Statistics section. There's like a list of professions, right? So we kind of plug that into the website and figure out what's the standard salary in a given field, in a location, and then kind of figure out what would be a relevant comparison. So we would do that, you know, we even do that from the outset when strategizing and talking about the case, right? We talk about what categories you have, and when we get to salary, it's either, you know, no, I don't have a high salary and let's not even discuss it. Or, you know, I always ask the question, what is your salary, right? How much do you make? If it's, you know, anything, you know, I'd say 100,000, 150,000 and above, I think it's worth a discussion depending on your profession, right? Because again, it's not relative to the world, it's relative to your field. So kind of pulling up the right comparison can make or break this category if it's a conversation that's going somewhere. Again, you don't need all of these categories, so this isn't something that you need to prove. Finally, the last one is comparable evidence. You know, I know there are attorneys that use it. It must be used well. I stay away from it because I think that for USCIS, they're looking at things, you know, in a very, again, those square pegs, right? They want to see you fit into their boxes. When you start getting into comparable evidence, you're asking them to take a leap. And anytime you ask them to take a leap, there's a risk, there's a danger, right? You want to make it very clear, connect every dot for them so that they don't really have to think about it. It's a given, it's already proven. When you have to prove something with evidence, you're asking them to agree with you that it's comparable to what they had asked for. You can see right there, there's a little bit of there can be a disconnect. So it needs to be, you know, it can be used strategically, it needs to be used well. It's not even relevant if you're in film or television. So just to be aware of that. And then again, just to repeat, I think it's worth repeating, you only need 3 of these categories. So the common ones for visual artists are leader starring role, in a, you know, production with a distinguished reputation, significance, and then your press category, which is where you cover your exhibitions and the press about your exhibitions. So it's national or international recognition is really the official title for press. So those are the ones that I would say, you know, we regularly present for visual artists, and then, you know, putting sort of your awards, your accolades, anything you've received that is prize-ish goes into significance, and you can support your significance category. Awards category is difficult. It's a challenge, it's a very high standard. And I think the danger is that if you don't meet it, if you try to do awards and the other categories, first of all, that's not the way the regulation, the statute is phrased. So there's that. But also, I think that more often than not, they're better suited to support your overall significance category. So that's just my opinion, but in case it's helpful for you all to know as you're thinking about the materials that you have and kind of taking stock of what you have, what you still need to get. All right. Moving on to other things that you need, in addition to the letters to support those categories, particularly significance, particularly critical role, if you're putting that forward, there's the peer letter. The peer letter is, you could think of it as like a significance letter, but like times a million, right? Like it's like the letter from the highest person in your network, in your reach, that you can get, that can say that you, that your work is extraordinary, that your work is important to the overall picture of your field, whether it's contemporary art, whatever your particular field. Now, you may have a very particular niche within the visual arts, right? So you might be a book artist, for example. So that's a very small corner of the visual arts. There are many small corners. And I'd say here's a place for you to really, you know, consider, and it's something that we strategize all the time. At the beginning of a case, we strategize a lot around like, what are we gonna call you professionally? And then like, do you have a particular niche that, you know, is your focus and your area? Because if you do, it's the sort of big fish, small pond, right? Like you are a bigger deal if your area is more concentrated and more focused. So that's just something for you to think about. You want to make sure the person is an expert, right? Again, it's institutional names, it's people associated with sort of more independent, that are more independent experts and less driven by any sort of profit motive. If you are in a profession that is represented by a union, so musicians, actors, anyone in film, whether you're producer, director, whatever your role, you probably have a union. Actually, you do have a union or multiple unions that you need to get letters from. So the example of a film producer, you need a letter from the PGA, and you need a letter, you need a letter from, you need another letter. I'm blanking on what it is, but you need two. Some areas you need 2 union no objection letters. What that letter is saying, it's a bit different from a peer advisory opinion letter, is that the union, even though you may not be a member of that union, has no objection to you continuing to work in your field. There are processes for getting these letters. So it's not like if you're a visual art, if you're a painter, for example, and you're putting together your application and you've got to start talking to people in your network or thinking about like, okay, this person's a stretch, how can I connect with them? I think they'd be helpful to sign a letter. They probably know of my work. It's not that. It's like going on their website. So you musician, you know, the AFM website has a place where you can just see what their process is. There's a fee for the letter. You have to put together a certain portion of your application, which includes the actual I-129, which is the immigration form, but then also some supporting documentation. So you got to do like a whole presentation of yourself to get the letter. There's a fee. It can be, depending, it can be $250, $350 for expedited. Maybe it's $450, right? So there's fees involved. Each union is different. And again, with fees, they can always change, but that's kind of the range that we're talking about. And they can give it to you on a 7 to 10 business day timeline. Expedited, maybe it's 3 to 5, right? It's that sort of a process. So just to kind of be clear on that distinction, that the peer advisory opinion letter you're getting on your own, you're sort of tracking down who the signer would be. And then for the union no objection, there is like an official process through each union. In terms of letter drafting more broadly, depending who you're working with, so like at Woods Law Group, we work with a managing editor who, you do a questionnaire, it's very extensive and thorough about you and your career. And then we work with someone who is expert at drafting these kinds of letters. So all you need to really do, besides be very thorough in providing information about your career and yourself and coming up with a really great signers list, we work with you on that, would be to actually have those people ready to sign. They can read, obviously, and edit, and they must. They can tweak the letter, they can change it if, you know, there are words that they would prefer to use or descriptions that, you know, maybe they want to provide. But basically, that's, because there's sort of this formula to the letter, I hate to use the word formula, but because there's sort of a format that the letter takes, I think oftentimes, if you haven't done one of these before, you might think you have to actually get people to go writing letters for you. And so it's not that useful to have a bunch of letters when they all, you know, maybe the same signers, you know, would be used, but you would need to sort of still rework the material. Okay. Sorry, that was a little bumbly, but I think you guys get the point. The next thing you need, and really this is a little bit in reverse order because this would be one of the first things that you figure out, is who your petitioner is going to be. So your application is not a self-petition. You're not applying for yourself to get an O visa. Someone has to petition for you. It's different from a sponsor. It's not the same thing as a sponsor in terms of the obligations of the petitioner. So, you know, a sponsor, if you're thinking about family-based immigration, someone who is sponsoring a family member is responsible for that family member, has to provide support to that family member if they become a public charge. There are a lot of consequences for, you know, to sponsoring someone to come to the United States. A petitioner is different in that the obligation is to be your petitioner for 3 years, right? What does that mean? Well, they need to exist in 3 years, right? So it should be a US-based company. So they need to be incorporated. They could be a nonprofit, right? They could be a 501c3. They could be an Inc. They could be a corp. They could be an LLC, a PC, but they need to be incorporated in some structure. They can be a US agent, or they can be a company that serves as a US agent. So let's take the case of like a gallery. We're gonna go through all of those structures and their relationships, but you can figure out and decide, you have a decision to make about whether or not the gallery is gonna serve as, you know, your representative. If they exclusively represent you, then maybe it's just a gallery relationship. If you prefer and you want the option to work for multiple employers, maybe that same gallery could serve as a US agent. So the US agent relationship is still through a US-based company. There's nothing in the regulations that says that your petitioner can't be an individual, but we don't do it because there's risk involved. It can be problematic and it's just not best practice. We always require that the petitioner is a corporate entity, that they're US-based, and then we can make decisions about traditional employment. If you just have a straight ahead employer, right, like you're just getting a job and that company is going to employ you and they've agreed to serve as your petitioner, great, that's what we do, right? That's gonna be your job, that's your itinerary, and that's the way it's structured. For visual artists and for people in the creative professions, broadly defined, right, that's rarely the case. I'd say that's much less frequent, although it happens. More often than not, you're gonna want the freedom to work on various projects, to do a bunch of different things. Or you're gonna have a gallery that's representing you, that's selling your work for you, and so you may just have a gallery relationship. So let's sort of look at what they are. So traditional employment relationship we talked about, you're getting a W-2, you're working for one employer, it can be full-time or part-time, but that's the structure, is that it's very simple. If you're working with a US agent, some agents operate as artist representatives and they will help you find work. Others just charge a flat fee. Normally it's, I don't know, anywhere from like $800 to $1,000 basically for the year, but I mean, they all have a different range of rates. We have US agents that we work with, and that's sort of the range, our range, but I don't really know what other what other US agents charge. I imagine it's about the same. But they're acting as your representative for purposes of this application. So even if they're not helping to find you work, and in the case of the companies that we work with, they're not finding you work. They're not agents in that sense. They're anchoring your application. They're serving in the role of your petitioner. So they're signing all of your petitioner documents, and they're agreeing to answer questions if questions arise from USCIS. So if USCIS wants to know who is this petitioner and are they legitimate, if they need to do research on them, that has been happening with increased frequency. So you want to make sure that it's a reputable, established US agent. They may do a separate signed offer, right? It may be that you're getting an arts institution to serve as your US agent and they've agreed to do it, to serve as your petitioner and they've agreed to do it as a US agent. It may be that they are also offering you employment, and you can have an offer and have your petitioner also sign your documents. They sign the application itself. They sign the legal representation form. So the attorney that you're working with is actually representing the petitioner, and you are the beneficiary. As the artist, you're the beneficiary of the visa. So it's a little bit of a different structure, but we work that way. The petitioner signs our legal representation form, but our client, so technically our client is the petitioner, but we work with you as the artist, right? Like we're serving you and your needs. But in terms of the formality of the application, technically speaking, the petitioner is the client in that sense. Okay, so if you have a gallery representation, gallery relationship, this is what it is, right? You're represented by a gallery. We need a signed agreement, and we submit that with the application. Similarly, for a US agent, we have a signed agreement, and then all of your offers of employment have to recognize that US agent. So they all have a clause in them that talk about the fact that you're represented by a US agent. There's a petitioner letter, which is a pretty standard format. It cites the regulations. It has information about the petitioning organization. So a summary. So if it's, if it's not a US agent company that just acts as US agent, we take something from, we actually do an intake sheet for the petitioner, and they provide sort of a blurb about their company. We want to make sure we get information about, their tax ID number, their gross income. So as you're thinking about suitable petitioners for your application, you want to be thinking, oh, but could I ask them for their tax ID number? Could I ask them what their gross income is? If it's someone who you also have a personal relationship with, you want to make sure that all of that is going to be workable. And then the letter talks about your background, your professional background, and your future assignments. And then there's an extensive few paragraphs that go through what the regulations say. Okay, planning your 3 years, right? What do you have to do for the next 3 years on an O visa? We want to make sure that your itinerary covers the full 3-year period. You're eligible to apply for 3 years. I don't see any reason why you wouldn't want to. Even if you're not sure that you're going to stay in the US for the full 3 years, sometimes that happens. That's okay. You would basically have permission to come and go for 3 years. So we always do a full 3-year itinerary. We make sure it's a clear chronology, like the way we're presenting it, we try to be as clear as possible. And we would try to make it very, very clear to the reviewing officer on the immigration side that this covers the 3-year period, that there are no gaps, right? So literally I print out a 3-year calendar to check the itinerary and make sure that all of the offers line up and there isn't any time frame within those 3 years where you're not going to be working. At the end of the day, this is a work visa. It gives you permission to be in the US and to be employed as an artist, right? And what that employment looks like is a little bit different from other employment visas, but that's at the heart of what this is all about. So I want to make sure that there's no way your application could run into problems or not be approved because, or approved for less time because it looks like you're not actually working the full 3 years. So we cover the full 3 years every time. As you're thinking about getting offers, think about that. Think about, okay, how, you know, what am I going to do for 3 years? That said, not every time frame needs to be employment in a traditional sense, right? If you're a creative professional, you're an artist, you know that there are times that you're doing things that are work, but you're not, you know, sitting next to your printer, right? You're not sitting in an office setting like working. You may be thinking, you may be getting inspiration. So some of the time that we block out is blocked out as preparation time, crafting time, right? So conceptualization, preparation, crafting, we may break out the itinerary into appropriate blocks of time that are relevant to your work. We want to, again, making sure that the events that you're looking to do are distinguished, and that has to do with that leader starring role and the future component of that. We want to make sure that we're thinking ahead and getting that right. So, you know, when you're looking at offers, making sure there's press about the places that you're planning to work. You may have various assignments and projects, and that's fine. Actually, that's great because it shows you know, the range of things that you can do. It also is helpful. Events can get canceled, and now more than ever, there's a risk of that. So what I would tack on to all of this is that what we've been doing is adding in language into the offer contracts about how this could be taken online, right? If it's an exhibition, it can also be done virtually. Whatever it is, we also figure out a way to describe how it could be done virtually. There had been a period of time where colleagues were experiencing requests for evidence right around March, April, when everything started getting canceled. We didn't have any where this happened, just timing wise, like we weren't at risk for it. But after that, I picked up on a couple of listservs that was like a trend that was happening. So we really started weaving in language about how things could be taken online, things could be done virtually. So just to kind of put that on your radar as well as you're thinking about future assignments, making sure that everything can be described as not in person. We don't have a vaccine for COVID, right? We don't know where this is going. So I think we can expect for things to start and stop and start and stop multiple times over the next 3 years, really, or beyond, right? We don't know when things will calm down, and just, you know, in terms of what's going to happen this year with an election, right? We just don't know what our future looks like. We know what it has been, and I think we should expect, we should plan for the way things are now, because we're kind of at a low. So we should sort of expect and plan around this moment that, you know, where things are sort of not in a great place. We should be planning that things will open and close, we'll see cancellations, and write that right into our offers and our itineraries. Your timeline has to match the visa period. So a lot of times clients will say, you know, I have this art fair that's coming up, and like it doesn't fit into the 3 years, or I'm doing something next month, but like we're not applying for the visa for another 6 months, right? So it has to, it's not just that you have these distinguished events, it's that they have to fit within that 3-year time period. Now, sometimes we can, if it's not a defined date, you absolutely have the creative license and the ability to set your agenda, right? Like work with your, the organizations that are offering you employment, and work with the timeline. And, you know, if you want to have an exhibition at a gallery next spring, because we've talked about it and I've said, like, actually there's a gap in your itinerary next April, what can we do about it? So we do have that flexibility to kind of build out the itinerary and personalize it to what you need it to look like. But there are things like art fairs and, you know, publicly, dates that are publicly available, and so those can't be moved. So, and also just making sure, you know, that if you're saying an event is happening on a certain date, that it really actually is, because they check, they look things up, they check if things have been canceled, they check if things are moving forward. Things can get canceled, like things can fall off your itinerary, and artists can always add events. So if there's something that you hadn't planned for that comes up, it doesn't necessarily mean that you have to file a whole new application. If your petitioner is the same and you've set it up so it's a US agent relationship, and then all of a sudden you're having an additional exhibition, and yeah, you can do that, right? Like, or a project comes up all of a sudden, you know, you're working for this other employer on, you know, a freelance basis, probably fine. I would say check with your immigration lawyer, because it's not always fine, and sometimes it does mean that you have to update USCIS. But that's not the default. That's not, and especially if you've got a US agent, right? Especially if you're working with a US agent, you've already built in that flexibility. Events can fall off your itinerary and events can be added. Okay, process and timing. So this is a tricky one because it's always changing, but currently, right now, in this very, very moment, we get approvals. I'd say we probably get 2 or 3 approvals a week. Things are moving in like a 4-week time frame. I'd say during COVID, things have been very quick, I think in part because officers are working from home mostly. So there seems to be a quicker turnaround. I think that's about to change, right? And everybody's probably seen the news headline that there are going to be major furloughs. 13,400 USCIS employees are about to lose their jobs indefinitely. And that's about to happen August 3rd. So my guess is that this quick turnaround that we're seeing, this really nice, like, submit an application, get the receipt in a week and get your answer, I don't think it's going to last. How long will applications take is kind of anyone's guess. So I would say buckle up. The bright spot is that premium processing is back online. It had been on hold. So you can pay $1,440 on top of the $460 filing fee for an O1 visa. So it's like $1,900 to do it. But you can do that and have your case decided in 15 days. So things are about to slow down, but premium is back online. So that's the like news update there. Will they necessarily slow down? You know, it's anyone's guess, right? Like, we don't really have a crystal ball about it, but my guess is that if there are fewer people reviewing the applications, it's logical that they wouldn't go as quickly. Right. So this is just a little timeline of how we kind of do things. Of course, there's a lot of variation depending on, you know, an individual situation, but usually we decide on the petitioner pretty much up front and the offers of employment. And then I literally print out that 3-year calendar and see where the offers land, where they fit. If we need an additional offer, I would tell you that. I would say, like, we're really only covering a year and a half. What else can we do? Or if one of the offers doesn't look distinguished, offers that are outside of the US are not really relevant to your application. It doesn't mean you can't work internationally. You definitely can. And opportunities that present themselves, you know, of course, you're going to want to go for them, and that's great. But it's not relevant, you know, from the perspective of, like, if you think about it as like USCIS is the US government and they care about you're working in the US. They're not so concerned if you're working in another country, right? So those are not things that we necessarily put in your itinerary unless it's like a US-based gallery and you're doing an art fair, you know, you're doing like an art fair in Hong Kong, let's say, for example. Then that would go on there. Similarly, if it's an international gallery and you're doing an art fair for them, you have an exhibition at an art fair in New York City, something like that. Like, that's where we would kind of have the flexibility. For the most part, you want to be getting US-based employment for your itinerary. So we figure all that out, your petitioner, who it's going to be, your offers of employment, we lay out the itinerary, and then we start to collect evidence. Not next, necessarily, kind of in parallel. So you fill out your questionnaire. What we do is we give you a Dropbox link, different different practices work differently. You may upload to a portal, right? Like that's another way to do it. But the idea is that you're collecting your evidence. So if you're working on prepping an O visa application for the future, make sure that you are maintaining your own sort of Dropbox of all of the press articles about yourself, about the institutions that you've worked with, your exhibitions. I didn't say earlier, but like catalogs and things are great to have, invitation cards, but they're of limited value in terms of like evidence, right? So they're not great proof. They are really beautiful usually, or they are really like nicely done and well presented. So they come in handy, but I would say like having a bunch of like invitation cards and catalogs is not enough. But those are also things that you want to collect in terms of documentation. And we would prepare the actual immigration form. So all immigration forms start with the letter I, as all of you I'm sure know, right? So it's the I-129, and then that's what goes on top of your packet. And that's what your petitioner signs, and we complete all of the fields in the form and put your evidence under it. We would submit the application, get the receipt notice, and then the approval notice would come. The timeline I've kind of already laid out. I think it's, you know, about to change, but it had been a week for the receipt and then 4 weeks for the approval. So to prepare the file, you know, that's another time frame that I think is really important. I think different practices work differently. It's usually on average 3 to 6 months. We can certainly do it faster, and I think anybody could, right? But it's just a matter of like working with multiple clients and juggling multiple cases. And so that adds to the time. Also, figuring out signers and offers and these things, they're pretty it can be pretty time consuming. Also getting things back signed, a lot of times it happens very fast, but other times, you know, people drag their feet. So just sort of depending on how you manage your aspects of the case and getting your documents in and getting your signers to sign, that's the sort of range between 3 months and 6 months. That could be the difference. I think doing an application in under 3 months is ambitious. As I said, it can be done, but it's there's just so many moving parts and things that you need. So, you know, if you haven't worked with an immigration attorney and done this before, I think it's important to know that you got to kind of give them a minimum of 3 months. You can't be like about to, you know, have your status expire and expect they're going to prep your O1 visa application overnight. It's just not reasonable. Yeah, it's just, there's a lot of documents and a lot of moving parts. So making sure you build in that time frame. In terms of like when you can apply for your next OVC, you can apply a year before the expiration of your visa. So I would say starting early is always a good thing. It doesn't mean that you have to have overlapping visas, right? It means that your itinerary, you're planning your itinerary to start when your current visa ends. So if you're on an O visa now, just to take an example, that expires next July, what are we, July 16th? So if it expires next year, July 15th, July 15th, then you could start applying today, right? Like you could call your immigration lawyer up and be like, I want to get started today, right? You have a year, you could actually submit a year before, but your itinerary wouldn't start until July 17th, right? Like, so you'd be planning your itinerary just to start after your current visa expires, but you can start the application process and even submit the application 1 year in advance of the expiration. So that's rare that it happens that far in advance, but I would say giving, you know, kind of pinging your legal team, if you're retaining counsel for the first time, getting them in line well in advance of the time that your status expires is really important. Processing time, you know, I talked about the fast timeline we've been experiencing lately, but on average, I'd say it's 1 to 3 months. I've seen processing times go longer than that, but not in a while and not across the board. So it may be that there's the rogue case, you know, just like there's the one case, everyone has a friend whose case was approved in 5 days, right? There's similarly, I think, the one friend whose case has been pending for like 6 months and no one knows why. So I think this is like the average. 1 to 3 months is pretty much the standard time frame to be expected. And then there are trends lower and higher. And then, you know, anomalies. Premium processing, as I mentioned, is 15 days and the additional fee of $1,440. So I just laid out the fees here. You know, not really wanting to comment on attorney's fees because there's some ethical rules around price fixing and things like that. But this is kind of the range that I think you see if you begin to sort of shop around for immigration lawyers that specialize in O1 visas. I think $3,500 to $6,500. Beyond that, I think it's starting to get a little high, although it exists. And, you know, I think there are lower prices out there as well. So there's pretty much a range. It often depends on the complexity of the case. And it may depend on the turnaround time that you're expecting. Fees for USCIS, we've talked about it. It's $460 for regular processing, $1,440 on top of that for premium. There is also a fee if you are consular processing to get the visa. So that's $190. There's a couple of ways to do your application. It depends on if you are extending your stay, if you're changing your employer, or if you're doing a fresh O visa application, maybe for the first time, like coming out of your OPT, for example. If you're or if you're applying from abroad. So like there could be, you know, the option that you're not yet in the United States, but you know that you qualify for an O visa, you contact an immigration attorney in the US, and you're applying from overseas. So there's lots of ways to go about this. If you are extending your stay, then you are extending your stay. And if you're in O1 status, you're extending that for 1 year, right? If you're doing the same structure as far as your petitioner goes, if it's the same employer. If you're changing your employer, you can apply for 3 years. So you don't have to leave the country, and you can extend your status. This is particularly relevant right now. Normally, standard process and the way it's sort of laid out in the regulations is consular processing. So going back to your home country, if it's your first O1, having the option to go to a third country if it's not your first, but going through a process called consular processing. All that is that there's a form. Of course, there's a form. There's a website and there's a form, and you fill it out, and then you would have an interview at the US consulate abroad. So you may have to go back to your country. If it's not your first O visa, you can go to a third country. It's important to sort of talk with an immigration lawyer. We certainly have places that, you know, we know are friendly to O1 visas, but not all consulates see that many O1s. So it may be that it's better for you to choose one consulate over another. So that's like another sort of strategic decision point to consult with your immigration lawyer. But the fee to file that form is $190. And then once you've filed it, you schedule your interview. We'll talk a little bit in the next section about what this is looking like right now with COVID, but normally you would schedule your interview and travel, and then have your interview and get your visa back definitely in under 10 days, right? Like usually within a week, you get your passport back with your new visa in it, and you can travel on that visa. You're eligible to schedule your appointment 10 days before the start of your approval notice, right? So this is all post submission and approval. You still have to get the visa. If you do an extension, you stay in the United States, but once you travel outside, you need to do this process, to consulate process to come back, right? Like a visa is for entry. So just thinking about it that way, you can have an approval notice and your stay in the US is legal, you have legal status, but once you leave, you've got to have a visa to re-enter. And if your old visa has expired, you then need to do this interview and consular process. So you fill out the DS-160, you pay the fee, you schedule, right? So important to keep your immigration lawyer updated on your whereabouts and your plans, even if it's just like a vacation. Okay, so just to kind of talk about that, and then we'll talk about what the consulates are looking like right now and where this is headed. And then, you know, it's sort of just a strategic conversation to have and a thought process for you as to what you decide to do. So I think we talked about this already for preparation in terms of like setting up your own place, whether that's a hard drive, a Dropbox, a folder on your desktop. It doesn't matter, although your files are probably large. So you want to make sure you have enough space to collect all your press, label it, make sure you know what it is, make sure you've got the whole article, right? It's not enough to submit just the clip that's about you. You want to have the whole article. You want to have the source, the date, the author of the article. Again, self-publishing, not really going to cut it, but you can write things and pitch an article. So all of that, you kind of need to be your own PR person. And I think that is the best route. Just anecdotally, I've had clients hire PR companies, and depending on your budget and what you can do, the articles that you're likely to get back are not going to be worth much for this purpose. So making sure that you are your own advocate, getting yourself mentioned when there is an article, when there is an opportunity to be interviewed, take it, even if you're feeling shy about it, get yourself in front of the camera, get yourself across the table from someone who's going to ask you questions about your work. It will benefit you. Get your name mentioned, get a quote, get your work photographed, and get out there in the spotlight. Make sure that as much as possible it can be major media, but you know, I would say like smaller things, you know, don't turn them down, right? They can still be helpful. Okay, so we kind of covered that, just reviewed it now because it's like so key for you, the success of your application. Juries and solo shows. So judging the work of others in your field. I say that because it can be a little tricky. You can judge the work of others, and technically, well, first I should say this is a separate category for purposes of the EB-1 green card. So judging the work of others in your field or an allied field is the way the regulation is laid out, is its own category. It is not a category for the O1 visa. However, I would say, because I know many people and many of Woods Law Group clients are serial O1 holders, and you can be, that's fine. But we like to think of like building toward the next step. So of course, not everyone's intention is to come to the US and live in the US, right? That's not what everyone's going for. That may not be your goal. Your country may not allow dual nationality with the United States, so that's something else to think about. But if you are thinking about living and working in the US, you know, particularly New York, right? This may be the city that you love. It may not be the country that you want to be in, but it may be the city that you love. So if it is, and if you're, you know, established here and you want to have multiple O1 visas, something to think forward to. And the nice thing is, again, highlighting good news where we can, right? The EB-1 green card exists. It is very similar to the O1 visa in terms of the categories that we all just talked about, but the standard is a lot higher. So the standard is like, you know, that doesn't mean that, you know, some of you probably already do qualify for it, but it doesn't mean that it's not something you should be working toward. It just means that's something to keep in mind. And I'm mentioning jury here not because it's applicable to the O1, but like your next move after your second or third O1 might be very logically the EB-1 green card. So if you've already got a jury under your belt, if you've already done a jury and you've judged the work of others in your field, I say, or in an allied field, that is what the regulation says, but I think their preference is for you, you know, if you're a visual artist, judging the work of other visual artists, if you're a curator, judging the work of other curators, that can be tricky, but it exists. So making sure that you're judging the work of your peers the idea is that you've reached such a level of extraordinariness that you are now called upon to judge the work of other people. That's sort of the thinking behind the category for the EB1 green card. You can submit evidence of having done that for the O1 visa. So again, where we would put that would probably be significance, because it is an honor in and of itself. But I mention it because if and when you're ready to apply for an EB1 green card, it doesn't matter if you did it 5 or 10 years ago, or whenever you did it. If you have the evidence, you only need one jury, and then that's a whole category. So just in terms of like thinking strategically for the future, kind of put a pin in that one. Okay. Seek out opportunities to be on a selection committee. These things may just fall into your inbox. And what I would say is, similar to interviews and things like that, don't turn them down, right? Take advantage of them. Selection committees for exhibitions, residencies, things like that. Then the mention of solo shows, and we kind of touched on it before. There was sort of a question in the chat about solos versus groups. Solos are more valuable in terms of evidence, in terms of like the legal evidence. It's easier to show, for the reason that it's easier to show you how to lead and starring role. That doesn't mean group exhibition. There are artists with only group exhibitions on visas, and it's fine. It's just a matter of making sure that you prove that the role was lead or starring. Okay. Residencies, fellowship, and award. It's important they go in significant recognition category usually rather than the awards category, because the standard for awards is very high, and it's it's just kind of where they fit, and we've had success with that. Travel restrictions. So we're into sort of the hot topics part of the presentation. This is kind of hard to cover because every day in my inbox there's a change. So I just kind of put these data points out there that it's something you have to check, right? Every country is in the same position of determining how people can come and go, who can come and go, what they have to do when they get there. So, as was announced probably back in April and then again in June, we saw sort of the US travel bans and the need to quarantine and be somewhere else before entering the US if you're coming from a Schengen country, right? So if you're coming from the Schengen region, you gotta go somewhere else for 14 days before you enter the US. That still holds, that's still the case. I could give you, just to flesh it out a little more if it doesn't make sense. I have a client coming from the UK who will be traveling through Mexico. So he'll spend 2 weeks in Mexico before entering the US on his O1 visa, because he can't fly directly from the UK. The same is true the other way. So a lot of people on O visas, not on O visas, a lot of people are going to Croatia, stopping there, and then any other point in Europe that's not within the Schengen region. Some countries are partially open, so it may depend on your citizenship, where you're coming from, as we've said, and then other regulations. There are no specific dates for reopening, but every day, as I mentioned in my inbox, there's some change somewhere, right? I got one about Slovenia today. So it could be, it could be the day that like the particular country you're interested in going to is opening or closing. And so it's just something to kind of watch. But, we can talk more when we start having more of a discussion. If there are specific questions, I'm happy to answer them. In terms of consulates, it has been, a challenging time in the sense that since March, people who've wanted to consular process to re-enter the US on their newly approved visas, not issued because they don't have them yet, but with the approval notice, going to interview at a US consulate has been a challenge since March because consulates have been closed. So there was hope in March, there was hope, and there was sort of an announcement that March 11th was going to be the date that things, there was a plan. And I was on a call where they said, you know, all of the consular officers were sent home back to the US. So that was the reason. And then the announcement never came. And then it was very like, what's the word? It was very like spotty as to which consulates were open and which ones were closed. And then it was just like crickets, like nobody's open, because clients who were scheduling were getting canceled, were getting rescheduled dates months away. So if they had an appointment in April, they were getting a date in September. And then it turned into, so it was very much like an evolution. So the next thing that started happening was that people were seeing emergency only. So like logging in, paying the $190, and then just seeing emergency only when they went to the calendar to schedule the appointment. So for a while, it's been emergency only, and we have had limited success having people enter, you know, on an emergency basis for work reasons, but, you know, that's not a process that's reliable that you could, you know, reasonably expect to utilize. So in terms of consular interviews, they have not been happening. However, as of yesterday, 2 days ago, the 14th, there's an announcement by the Department of State that they would begin reopening. There's no specifics yet, but there is hope that there is a plan in place for a reopening. My guess is that that will probably be after the summer or in some limited capacity through August and into September. I think we'll see some more availability at different consulates around the world. But I don't think it's going to be like a complete reopening. I think that there's going to start to be some movement and some processing happening in different places. So it's sort of a, you know, to be determined type situation, but that's been kind of how it's gone. And a lot of people, you know, have been stuck as a result. Or, you know, I have a client in the situation where she has an approval notice, but she has not, because of travel restrictions and the consulate being closed, she hasn't been able to actually go and physically get the visa and her passport. What we're doing in those kinds of cases is extending, where we can, we extend the stay. So we file an extension of current status. In her particular case, she's on an O3 visa, so she hasn't had her own O1 until now. So it's a little bit of like, there's nothing to extend. Her O3 status is still valid, and so she's, you know, sort of stuck kind of waiting for that. So, I mean, there are people for whom, you know, it has had a negative impact. Where we can, we're doing, you know, an extension of current status in addition to, you know, the other approval, or we're doing new applications as extensions versus consular processing. So we've adapted our practice in that sense. Okay, so I gave you this right up front, just so you wouldn't have to wait till the last slide to see it. Student visas, the restriction has been lifted. So July 6th, the administration, for those of you who didn't follow it, but I can't imagine there's anybody who didn't follow it, the Trump administration restricted F1s and M1s. M1s are for like vocational study at institutions who are offering online courses. So basically they were saying, if you're on a student visa and your school is only going to be online, you can no longer have that status. We're not giving you a student visa to take courses online. You know, which was completely stressful for students and really left a lot of people in a position where they needed to really rethink what they're doing, plan to go home. Travel restrictions limit some possibilities of where people could go. So it's just really a bit of chaos and stress and headache. Harvard and MIT brought a lawsuit, and then many, 18 states attorneys general joined the cry, and tech companies jumped on board and said this would be, you know, really crippling for our companies as well. So, and it's just not a terrible precedent to set. So that was just completely stopped in its tracks. So that's a little bit of good news. We have several presidential proclamations that are in place since April, and then there was another one in June. So the suspension of the issuance of green cards, is still in place. And then several visa categories are, I don't want to use the word suspended, but are impacted by those presidential proclamations. So I'm happy to talk about those if people have specific questions, offline, but just to kind of highlight that there are other things in the category of obstacles, to be faced. So H-1Bs, L-1s, J-1s, all impacted. O-1s for now have not been impacted. And I think, in part that's because so many tech companies rely on the O-1 visa for their teams to be able to do their work. Film and television, obviously. So there are a lot of industries that are supportive of maintaining the O-1 visa. And for whatever reason, it just hasn't been a target. That's not to say it won't be, but just, so everyone's sort of on the same page. And that concludes the presentation on O-1 visas. I'm really, really grateful that you all were able to make it live and be here. And I think we can turn it over to Q&A so that we can actually have a conversation. Yeah? I'm gonna go like this. Okay. Okay, so I know there are some questions from the chat, so I just want to I don't want to get to them. Okay. Right, so I think I tackled this first one. Current status of expedited visa applications. So for O-1s, premium processing is back. It's back, so it's fine to use it. It's there to be used, right? It's just that additional fee. I would always, again, recommend checking fees because they do change. Yeah, I think that, so there's a question about what institutions can do to demonstrate the importance, to bolster applications for artists, and how can an institution stay up to date on what the new requirements are to make sure that programming is friendly for artists, for international artists. And I would say, one thing, I spend time talking to petitioners just to sort of educate them on what the obligations are. I think there can be a lot of fear. So, the fact that you're asking this question indicates to me at least that, there wouldn't be a need for that type of a conversation. It's more around, I guess, attracting international artists or letting artists know that, you would be willing to sponsor them. And I think saying that outright, would be really, really helpful. I think letting artists know that a lot of times clients are, artists that come to us for representation are not sure who they could ask, right? They're not sure, like they may be working with an arts institution and feel uncomfortable asking that they would, for them to serve as a petitioner. So if I look at someone's CV and see that they've worked repeatedly with the same institution, I might suggest that that could be a logical place to serve as a petitioner. So I think, just opening that conversation, if someone is international and they're an artist, it's sort of a logical conclusion that they might be on a no visa or looking to be on a no visa. And so I think saying pretty directly that you would do it. Yeah. I think just that direct communication would be really helpful. Okay. Right, so I think this is a question. So there's a question about getting your visa into your passport, And the travel restrictions, is it risky? You know, it is risky right now to travel. And so I think if there's any way not to do this right now, I would say limiting travel is the answer, unfortunately. I don't like that to be the way of the world, but there are so many restrictions and they are changing very regularly. So particularly around consular processing, I think it's about to shift a little bit. And so there may be some room to go out, get the visa and come back. But as I mentioned, I have a client in this similar situation who has the approval, but no visa. So yeah. Okay, so if you have individual questions about your particular situation, you can feel free to email me or give a call, and I'm happy to spend some time talking with you about your situation. Right, so interviews, so there's a question about where interviews fit in terms of the evidence categories. Artist interviews are, great for press. If you're interviewed, in some other format, I think getting it into a format that's published would be the goal, right? So if you're interviewed, having someone film it and getting it, even if it's on Vimeo, right, or something, we've had that, or if it's published somewhere, but it shows up on YouTube, maybe we could use that. You could use that as support to your application. Okay. I think, sorry. Just gonna try to pick some questions from here. I'm seeing a note about time, so I want to just pick sort of some of the most salient questions to kind of, things that apply to everyone. So teaching comes up a lot, teaching in your field. If it, counts as a starring role, and, if it's submitted with supporting letters, absolutely, I'd say it's a leader starring role, right? Like you are the focus. Oftentimes, you're invited to talk at an institution or to give a course at an institution because of your expertise and because of your reputation. So I would say absolutely teaching at a university, clearly you have a lead and starring role. I don't think there's anything that USCIS could really quibble with about that. Where there is the most common, where there is an issue, could be around, and it's more on the college or university side and academia, which could be a whole separate Zoom conversation, right? But like what contract they're willing to give you. So we'll often include artist lectures, whether you're, an adjunct, a teacher, professor, or what have you. If you're giving an artist lecture, even if it's a one-off event, we might include that on your itinerary. If you're invited to teach at a university, yes, I think it's a leader starring role, but where the issue often lies is around the employment relationship. So if the university is employing you as a 1099 employee, if they're going to pay you as an adjunct, what is the contractual relationship and where does that fit in terms of your employment? We do it, it's fine. You can be represented, let's say your petitioner could be a US agent, and then you could have that as one of your events on the itinerary. I think that's the safest way. But that's really where the issue usually lies with teaching, rather than sort of, is it a leader starring? Well, clearly it is leader starring. Okay. Yeah, so significance, I think, is different from your critical role category. In that, significance, you're really talking about like your reputation broadly in the art world, in your field. So, why are you significant to your creative profession, right? Where critical role is more of like on a micro level, your project was a success, or your, this gallery was a success because your artwork sold for a lot of money and gave them great financial success, right? These examples of like, but it's more it's smaller, it's more on a micro level, where significance is broadly defined, your field, why is your work important? So I hope that's clear. Significance is almost always significant recognition. You're always going to do that category as an artist. Critical role, it depends. Okay. So we talked a little bit about renewing your visa after 3 years. There's a couple of different ways to do it, and it depends on your employment situation. So if you are going to be working with a new employer, you're gonna file change of employer. There's a box. That's why I'm going like this on the I-129. So you check a different box depending on the situation. If you're working with the same employer, you are really technically, and I know there are probably stories of people who have done it and been successful, but you're technically under the regulations only eligible to extend for 1 year. So if you want to do 3 years extension of stay, you would want to work with a different petitioner. That's sort of the short way around to answer that one. And right, the next question is exactly that. If you have to renew your O1, you've changed your agent or employer, that's totally fine. You can definitely do that. You can change your petitioner. If you're doing it, like let's say you're 1 year into your 3-year visa and you've decided you're gonna work with someone else or someone else is employing you, that happens, right? Employment situations are very fluid. If you've set it up as a US agent relationship, it's okay, mostly, check with your immigration lawyer, but it's usually gonna be okay for you to add an event. If you're changing, I don't know why you would, but if for some reason something happens and you're changing your US agent, then you need to file change of employer, extension of stay. These are your boxes. If you are employed by somebody new completely, like let's say you didn't file with a US agent, you filed with an employer as your petitioner because your work is mostly W-2 work, you're doing something very worky, like, right? It's the same work and you have one job and one petitioner, one employer on your itinerary. And now you've got other projects coming through and you've set it up so that your petitioner is one employer and your itinerary says you're going to do one thing. You have to file change of employer, extension of stay, and then your petitioner is a new entity. And then if things fall off the itinerary was the other sort of variable that we talked about, and that happens, and you don't have to file anything. So it's important to have those conversations because it's not always clear depending on what's happening in your life professionally. It's not always clear where it falls, how your fluid life fits into these square boxes. So it's important to have that conversation with your immigration lawyer, but that's usually how it breaks down. Okay. There's another part of the question about the current administration. So yes, you can add jobs to your itinerary, and it is safe to do under the current administration. As I mentioned, O1 visas have been, I say this like, I don't want this to change, but have been somewhat unaffected by the current administration. There have been trends, up and down in terms of timing and processing times and things like that. There have definitely been, there was an uptick in requests for evidence at some point, I want to say in like 2018, 2019, right? Things that before wouldn't have been an issue. Certainly things are being held to the standard and requests for evidence are being issued in places where they never would have been. That is true. But in terms of what the regulations say, and if you follow that pretty closely, you really shouldn't run into too many obstacles. Okay. If you have, again, specific questions, I can definitely take time and talk with you. If you email or call me and let me know you were here at this talk and you submitted a question, I didn't get to answer it because it didn't really apply to everyone. I'm happy to take time and answer those individually. If you apply with a new lawyer, your change of lawyer shouldn't really affect your application. I think the key is making sure that your new lawyer has all of your materials. A new lawyer may present things differently or may have a different format. Like I've had people come to me with their prior applications, you know, and it's not the way that I do it. It doesn't mean it was wrong. It just means that everyone has a sort of, you know, has their way of doing things, or a format for their letters, or different page dividers, those kinds of things. But it, you know, doesn't mean one is wrong or one is better. And certainly it doesn't impact, you know, the approval of your case. You know, just if it was well presented or not is really what's at the heart of that, right? And there's no consequence to changing lawyers in terms of how USCIS views your application. Specific situation. Sorry. Okay, peer letters. Right. So this question is, what about peer letters? Right now, only Fractured Atlas offers letters for visual artists. Have they broadened this at all? Yes. Thank you for asking this. Absolutely, they have. You do not need to rely on Fractured Atlas. Fractured Atlas letters are a little bit iffy. I think they're not as strong as other sources. First of all, you never, as a visual artist, needed to rely on Fractured Atlas. It's certain professions. I think maybe what this person is asking, because unions during the March-April period at the beginning of this global pandemic were closing. They weren't as responsive, and some unions were not issuing letters at all for this purpose. They quickly regrouped and reopened. I think it was a matter of just like offices needing to settle in and work from home. So at that point, I was actually working on a film producer's O1 application. And as soon as I regrouped and figured out, okay, Fractured Atlas, here's the alternative, here's what we can present, the unions were back up and running. And we requested the letters from the appropriate places. So in terms of your peer opinion, advisory opinion letter, should really come from, I am of the opinion that it really should come from someone in your profession who's at a high level, again, neutral, expert testimony kind of thing, right? If you're submitting a blurb about you, their bio, your bio, what you're gonna do and why it's extraordinary. And then literally like advocacy at the end saying your visa should be approved. That's the format of the letter. So I would say go with a peer advisory opinion letter over Fractured Atlas if you are in a profession where you can do that. If you are not, I would say stick with the union letters. Fractured Atlas is something to talk about with your immigration lawyer. And if, you know, and you can call me, we can discuss it if you want. Okay, filmmaker. Working on the director of a film or show I worked on. Would it be better to use this letter for a critical role or significance? It depends. It depends. Sorry. Sorry, I picked that one because that's sort of a specific situation. You can definitely email me, you know, if you need sort of a thought partner on that to think that through. I'm happy to help strategize, or if you're represented and you have a lawyer, talk about it with your lawyer. Okay. Here we go. Some lawyers think too many letters of recommendation are overkill and recommend 5 letters. I think it's good to overwhelm and work with 12. Others think you should have 12. It's good to give them too much. My view on this, and this is not only my view, this is my mentor attorney who I work with, and then the managing editor who specializes in letters for this area. I've kind of come to, there's no magic number. To be clear, it's right that some lawyers use 12 letters, some use 5 letters. Our number is 4. We're not right, they're not wrong. It's not like that at all, right? It's just a question of like, at some point it is true, 12 letters is probably on the extreme side, it's probably too many. There's a point of diminishing return, right? Like what else are people gonna say? How do you know, 12 people, what are they gonna say about you? It's gonna add to this USCIS officer's take on everything else you've submitted. I think 4 or 5. Sometimes people have 6 really solid signers and we want to get them in there because maybe, you know, maybe it's like a letter from the MoMA, a letter from the Whitney, a letter from, like, we don't want to cut some good stuff if there's like real name recognition to where the signers are coming from. then we keep it in there. If it's 12 letters, you can probably edit that down and make some choices about, you know, again, where is this person affiliated with? Again, if you're in a niche corner of the arts, right, you might have people that are particular to your area that are really important to have sign letters for you. So again, it's really just about curating that section. You're right, there are a lot of opinions. Our number is 4, but you know, we go over that if there are good signers to use, and also, you know, there's no magic number. Okay, I think we're at time, a few minutes over. So I want to kind of cut it off there, but there are still some really good, juicy questions here. So I think that if you asked a question and it's on this list and it didn't get answered, you can email me and we can set up a time, you know, to chat and to talk by phone, or I can answer you over email if it's a really simple one. If you want to talk about your specific situation, I'm happy to set up a consultation to do that. So it really just depends on, you know, your needs and what you're looking to do. But it was really a pleasure to kind of be here with all of you and to have the opportunity to speak with you on, I think, this really important topic. And I hope it was relevant. We wanted to kind of poll you and see what your status was, but we felt a little bit uncomfortable about that just because that's a really kind of sensitive question. So feel free to get in touch with me outside of this context, and you know, you'll see me here in my bedroom office, but that's where I'll be. So thank you again, and thank you to the Q Foundation, to Josie and Lily. I really appreciate the opportunity.